Welcome to The Explainer. When most of us think of justice, we immediately picture these grand courtrooms, heavy wooden gavels, maybe some flowing black robes. But behind the scenes, there's actually an entirely different, incredibly powerful alternative justice system operating right under our noses. It affects your taxes, your workplace, the environment, even the products you buy every single day. And yet, it remains largely understood by the general public. So today, we're going to unpack exactly how this hidden engine of governance really works. Are traditional courts becoming obsolete? It's a pretty provocative thought, right? Obviously, our traditional courts remain absolutely fundamental to our democracy. We literally cannot function without them. But here's the harsh reality we have to face. They are drowning. They're just completely overwhelmed by the sheer scale and complexity of the modern welfare state. We demand so much more from our governments today than we did a century ago, and the traditional court system simply was not built to handle the absolute avalanche of highly specific, super technical disputes that come with that territory.
Okay, let's dive into this. We're going to start with the modern court crisis. Then we'll introduce the tribunals, explore the principles of natural justice that protect you, look at when fairness actually gets legally paused, and finally, the severe cost of getting all of this wrong.
Part 1. The modern court crisis. Overloaded and overwhelmed.
To really understand why we needed an alternative system in the first place, we first have to understand the tremendous pressure placed on our existing one. The modern welfare state regulates virtually every single aspect of our daily lives. Governments aren't just out there maintaining basic law and order anymore. No, they are actively managing taxation, public services, industrial disputes, environmental protection, you name it. And as governments took on all these new functions, an absolute flood of disputes followed. Just imagine trying to run highly complex scientific or financial conflicts through a system that was built centuries ago. The ordinary court simply couldn't keep up with the sheer volume or the technical nuances of these cases.
Think of it kind of like this. Ordinary courts are like general practitioners. They're fantastic, they're essential, and they have incredibly broad knowledge. But they're plagued by massive backlogs, procedural delays, and they struggle with highly technical complexities. On the flip side, we have administrative authorities. Think of them as the medical specialist. When you have a really specific, highly complex problem, you don't just want a generalist, right? You want a specialist. We desperately needed a system that could deliver speedy, cost-effective, and expert justice, which the traditional generalized court system was just really struggling to provide in these niche areas.
Which brings us to Part 2. Enter the tribunals, the justice specialists.
So the crucial point is that the solution to our crisis came in the form of administrative adjudication. Tribunals are not traditional courts. They are these highly specialized statutory bodies created by parliament or state legislatures. And what makes them so incredibly unique is that they exercise what we call quasi-judicial powers. Basically, that means they combine deep administrative expertise with actual judicial functions. In the Indian Constitution, for example, their foundation rests solidly on Articles 323A and 323B. They are custom-built from the ground up to decide disputes and determine rights in very, very specific fields.
So why are they so effective? Well, because they focus exclusively on specific areas like labor or tax. They possess incredible technical expertise. But honestly, their biggest superpower is procedural flexibility. They cut right through the red tape because they generally aren't strictly bound by those massive, complex rulebooks like the Civil Procedure Code or the Evidence Act. This allows them to deliver justice that is not only way faster, but incredibly economical, all while lifting that crushing burden off our traditional judiciary. But wait a minute, if we're just bypassing strict court rules for the sake of speed and flexibility, aren't we creating a kind of dangerous situation? If these tribunals have so much power, what actually stops them from becoming arbitrary dictatorships?
And that leads us to Part 3, Principles of Natural Justice, the ultimate safeguard.
This massive safeguard is known as the Principles of Natural Justice, and its very first pillar is this timeless Latin maxim, nemo judgex in causa sua, which simply translates to no one should be a judge in his own cause. This is the absolute rule against bias. It strictly dictates that any decision-maker has to be completely neutral, entirely independent, and completely free from prejudice. Imagine a referee at a football game who is secretly wearing the jersey of one of the teams under his shirt. You simply cannot have a fair game. It's just not possible.
Now, what's really fascinating is how bias actually manifests in the real world, because it isn't always super obvious. First, there's pecuniary bias, which is any financial interest at all. In the landmark Dimes case, a judge's decision was actually thrown out simply because he secretly held shares in the company he ruled in favor of. No way that flies. We also see departmental bias, like in the AK CrPC case, where a candidate for a job was literally sitting on his own selection board.
Then there's personal bias, like ruling on a case involving a really close friend or a relative. And finally, policy bias, where an authority is just so stubbornly committed to a predetermined policy outcome that they absolutely won't hear reason. And here is the kicker. Even the reasonable apprehension of bias is enough to invalidate a decision. Okay, the second massive pillar of natural justice is audi alterum partem. Here the other side. This is the fundamental right to a fair hearing. It guarantees that no matter what you are accused of, you will never, ever be condemned without a genuine, reasonable opportunity to defend yourself before an adverse decision is made against you.
Let's look at how this builds step by step, because a fair hearing involves really concrete, non-negotiable steps. First off, you absolutely must receive clear, adequate notice of the charges against you. You got to know what's happening. Second, you get a real opportunity to actually present your evidence and your arguments. Third, you have the fundamental right to rebut or challenge any adverse evidence brought against you. And finally, the tribunal must provide a reasoned decision. That last step, it's absolutely crucial. Reasoned orders promote true transparency and accountability, basically ensuring the decision relies on actual solid evidence and not just secret whispers behind closed doors.
Part 4. When fairness is paused. The exceptions.
Look, as flawless as natural justice sounds on paper, the real world is messy. Sometimes practical necessity and extreme urgency just have to take the wheel. In an emergency involving imminent public safety or a sudden epidemic, the government literally cannot wait for a lengthy, drawn-out hearing to take action. The same goes for critical issues of state secrecy and national security. And sometimes it's just a matter of sheer impracticality. Think about it. If an administrative necessity involves tens of thousands of people, individual hearings might be physically impossible. Even in things like academic evaluations, courts usually step back and let the educational institutions decide. These exceptions are a very delicate high-wire act balancing ultimate fairness with sheer administrative efficiency.
But here is the brilliant safety net built right into the exception. In the landmark Maneka Gandhi case, this was where a journalist's passport was suddenly impounded without any warning. The Supreme Court established an amazing concept, the post-decisional hearing. What this means is that even when urgent, temporary preventive measures have to be taken immediately without a prior hearing, fairness isn't canceled, it's simply delayed. You still get your full opportunity to be heard right after the immediate threat is neutralized.
Part 5. The cost of unfairness when the rules are broken. So, what actually happens when a tribunal goes rogue? What if they just ignore the rule against bias or deny someone a fair hearing without a valid emergency? Well, this brilliantly illustrates the power of these rules. If these fundamental principles are violated, the administrative decision doesn't just get a little slap on the wrist, it generally becomes entirely void, nullified, gone. Unfair actions violate the very core of the Constitution, specifically your fundamental rights to equality and personal liberty under Articles 14 and 21. When an order is passed without a fair hearing or strict impartiality, it is fundamentally legally broken.
And the remedies available to citizens here are incredibly powerful. Through judicial review, high courts can completely set aside these tainted decisions or remand them for a completely fresh, fair hearing. Courts can issue really powerful tools like a writ of certiorari, which essentially deletes the unfair order from existence, or a writ of mandamus, legally forcing the tribunal to actually do its job properly. Because ultimately, beyond just breaking the law, bias and unfairness destroy public confidence in the entire justice system, and without public trust, the whole thing falls apart.
Which leaves us with this final, incredibly profound question to chew on. How do we perfectly balance government efficiency with individual fairness? As we've seen throughout this explainer, the alternative justice system of tribunals is this continuous, high-stakes tightrope walk. We desperately need the speed, the deep technical expertise, and the cost-effectiveness that tribunals provide just to keep our modern welfare state functioning. But we absolutely must forever anchor them with the uncompromising rules of natural justice to protect our individual rights. It's an ongoing evolution and a truly fascinating part of how our world really works behind the scenes. Thank you so much for joining me on this deep dive. Keep questioning the systems around you, and I will see you in the next explainer.